Today we are going to discuss in this video about the topic of abuse of dominant position in EU and UK law regarding non-pricing practices. Before discussing the various types of non-pricing practices, we will discuss the basic concepts of abuse of dominant position which are needed to understand whether an undertaking is abusing its power, being dominant in the market or not. So, the undertaking, while abusing its power, while doing an action which is independent in nature, if it is affecting the consumers and the competitors, then we can say that the undertaking is doing an abuse of dominant position. However, not only that, but if the undertaking has a substantial market power, and using that substantial market power, it can make limitations to the entry of the new entrants or competitors. And thirdly, what are the buyer market power of the competitor in the market? So while considering this, we can understand that whether the undertaking is having dominant position in the market or not, or whether using such dominant position, whether it is abusing its power or not. Having said that, there are two major things which are need to be covered while understanding the abuse of dominant position. What are they? First of all, geographic market. Second is product market. Product market basically means that whether there is any product which is produced by the competitor competitor of the undertaker which can be replaced in the market or not. So when the consumer have another replacement of the product, then of course the competition is reduced and the undertaker cannot abuse its position, right? So that's why we consider that whether we check it, that whether there is any product which can be replaceable in the market compared to the product of the undertaker. Secondly, geographic market. Geographic market basically means that what are the conditions which are taken by the undertaker in particular geography comparing to the other geography. So while doing an abuse of dominant position, the same condition will not be there in the another geography where they are giving their products. So if they are similar, then of course that is something normal. But if it's not similar, then that means that there is abuse of the dominant position which is used by the competitor, or not the competitor, but by the undertaker. So these are the two things which we need to keep in mind. Now there are certain exceptions which are provided in the TFEU, Treaty of Functioning of European Union. So in that, the exception says that if any changes are made which is good for the consumer and which is good for the technical development, then that cannot be considered as abuse of dominant position. However, under Article 102 of TFU, there are certain aspects which are given which can be considered as abuse of dominant position. Article 102 can be divided into two, that is pricing practices, non-pricing practices. We will be further dealing with non-pricing practices. Now, pricing practices basically means that when the abuse of dominant position is in regard with the pricing of the products. So if they are changing the pricing of the products using their position, then that can be considered as pricing practices. However, the non-pricing practices, under non-pricing practices, if they are doing something which is prejudicing the consumers, if they are making some conditions which is making the competitors not able to produce their product in the market, and if they are doing something which is not really needed for the selling of the product, then that can be considered as non-pricing practices. Examples are tying, refusal to supply, exclusive dealing agreement. This will be covered in the next video. So these are the basic concepts, these are the basic types which are covered under non-pricing practices. Now secondly, as we are also covering the UK law, so under section 18 of the UK law, the abuse of dominant position is covered. It is basically covering all the aspects which is being covered by the Article 102 of TFU of the EU law, right? Further, what is the difference? Basic difference between EU law and UK law is EU law is covering cross-border aspect. However, UK law is not covering cross-border aspect. UK law do not have any threshold. However, the EU law have some threshold while considering whether the undertaking is doing a abuse of dominant position or not. Thank you for watching this video.